All right, everybody. This is that time of the week, the Creative Finance Collective. Thanks for joining us. We're going to bring on, we got a couple folks here with us today. We've got Sean St. Clair who's here, and I think we have Scott Horne. Scott, can you hear us? I see you in a car over there.
I can hear you. Can you hear me?
Wow, I can hear you just fine. Where are you driving to, or can we know that?
Well, first off, just pray for me because I have Susan driving my car.
Oh, yeah, say no more.
Yeah,
Hey,
let me
Hey.
just tell you what. But no, we've been in Austin, Waco, and now heading back to Dallas.
Now, it's not creative finance related, but it is interesting. You guys are up there near where the path of totality is for that eclipse. Did you get a good glimpse?
Oh, so my first comment is the whole world went nuts over it, right?
Yeah.
They were shutting down everything left and right, this and that. Oh my gosh, all the crazies are going to be out, whatever it was. So that overpromised and underdelivered quite a bit. And so we got a chance to watch, of course, as it was going into a total eclipse. Okay, we've all seen that before. That was nothing really to write home about. But when the actual total eclipse happened, it absolutely blew you away. It was amazing to see it, what it did, the darkness that kind of fell, the crickets started chirping.
Mm.
Things, it was actually really cool to see. I have to be honest.
Wow, that's
It was neat.
yeah, I heard.
Yeah, I mean, granted, it only lasted like 3 or 4 minutes, whatever it was, but it was pretty cool.
Yeah, we didn't have quite that spectacular of a view here in Arizona, but we did go and see it. But saw lots of pictures of folks that were out in your area or otherwise in the path, and it looked pretty amazing.
Yeah, it it was much more than I thought. How about that?
Great.
I
Well,
didn't know what
so
to expect per se, but it was cool.
yeah, so if you're just now joining us, so what we're doing here, and if you haven't watched before, is we're talking creative finance and taking creative finance or real estate related questions. So if you have questions, we'll be on here as long as we have them. So make sure to post them. We do have a question. By the way, a little bit of housekeeping also. If you're watching on Facebook, you can scan the barcode at the top, and that'll take you to our YouTube channel where you can subscribe and follow. That would help us, and that's really kind of the best place to interact with our content. In the description, by the way, of the collective video on YouTube, you'll also see links to other members of our collective who are participating, like Scott, who was just talking. That also has a link to his YouTube channel. Good place to follow, subscribe, and follow like content. So, question that we got as a seller. What is the best way to find and market to sub-2 buyers? So I'm a seller and I wanna find sub-2 buyers. Is it enough to say we can just ask our realtor, "This is how we wanna sell it," or, "I'm interested in this, go find me these?" What do you think?
Well, as the guy that does that, my first question is you say buying a sub two buyer. So I look at that and I hear that and I go, are you talking about a possible owner occupant? Or are we talking about a possible investor or both? I think the marketing for those are both very
Yeah,
different.
I think it's just a seller that likes the possibility of maybe they've heard us talk about the idea that, well, start seeing your loan, your low interest loan as an asset, and people might like that, and maybe they think they can get more. So, but I agree.
Well, to,
I
to give you an idea, I was on the phone this morning and this afternoon with some different scenarios regarding that exact same question, by the way. So in this one situation, the loan balance is fairly substantial as to the value of the property. And the question is how do we maximize dollars? And you can't sell it to an investor because you can if you're going to use it as a rental property. But in this case, they needed to get a down payment from a prospective buyer that they could put in their pocket, and then let the buyer take over the existing mortgage as their homestead. Now, in doing that, the market to that particular person, obviously you can go with a realtor if you wish to do so. You can use what we call bandit signs. You can use Facebook marketing, Craigslist, other scenarios. I even do flyers to other realtors who have listings in the areas and things of that nature, trying to find that owner occupant per se along the way. Now, if I'm looking for an investor, however, could I do the same thing? I could. But I think that there are many other investor sites that you can advertise on that you can find online in whatever area you're in. I think you can go to the various meetup groups that are out there, and the key is going to be how can you get in front of as many investors as possible to do that. So I think you got similar but divergent tracks based upon who that end buyer is going to be. Now, can you list all those people at one time? It depends on what the seller's needs are. Is it cash in pocket? And would an investor pay the same amount that an owner occupant would?
Yeah. All right. We have another question. I'm starting to hear this from a Facebook user. I'm starting to hear that some states are prohibiting subto deals. Is this correct? And if so, what is the workaround? Have you heard of any recent legislation, Scott or Sean, regarding the prohibition of subto sales? I haven't.
Sean, you heard anything?
No, I haven't.
And I'll say the same thing too. I have not heard that anywhere. I've heard some rumblings about wraps of an FHA loan, issues that could come out of that. This is in the Texas marketplace only, not in other states. And yet I still don't know what that exactly is, or if there's any merit to it or not. It's some interest rate thing, which I'm still not on board with. I haven't heard it, so I don't want to propound it anywhere, because anytime you say anything and put it out there, it seems like it becomes gospel.
Mm.
And I don't see that being an issue, and I haven't seen anybody trying to curtail this. But, at the end of the day, guys, if you're going to do a subject to transaction, I think it is so important to make sure you do it the right way, that you give your seller full and complete disclosure. We're dealing with an entity right now that bought a lot of subject to properties, didn't honor any of the obligations of any of them, and they're scrambling to get these things sold off to protect the original sellers. There's a lot of people who have money invested in these transactions that probably won't get most of it back, or even all of it back at all. And if you're going to go buy a home subject to the existing mortgage, one, always protect your seller with a security document of some type so they can get the house back if need be. Two, make sure you use full and complete disclosure so everybody's on the same page, and intend to do things the right way. Because I think you still run into that greed factor out there. I think it's because you do a transaction that there's going to be a buyer for it or something else. And sometimes these investors get involved and they just unfortunately fall on their face, which becomes problematic and creates problems.
Yeah. Well, and another nice reason for why you ought to just do things the right way, regardless of whether there's rules requiring that you do that, is the laws come usually following bad activity, right? Where it's just become so out of hand. So if you keep your nose clean and treat people the way you want to be treated, which is really what you're talking about, Scott, when you talk about disclosure, just disclose what you're doing.
Oh yeah.
And then folks aren't really, then legislators don't feel the need to police.
Well, that is, let's just say amen to that the way it is, because it's absolutely the truth. And you keep trying to educate the marketplace, or we do all we can. It's a great business. It's a viable business, by the way, that really helps sellers. It can also be good for the investment world as well, and for the investor buying that property done the right way. But trying just to ramrod it down just to get a deal done because you think it might be a deal isn't always the best thing to do. So I know that on our end of the equation, both in Texas and nationally, we're always promoting those things because I think it's a viable positive that needs to be out there at all times.
So there was kind of a follow-up question, I think, as to what we brought up about the disclosure and subject to addendums. Um, Question: if I fail to provide a subject to addendum at the time I present the purchase contract to a seller, can I present it at another time prior to the close of escrow? In other words, sounds like, can I cure my failure to disclose at the very beginning of the transaction? The answer to that is obviously yes. How can they go about fixing their failure to disclose initially on the front end of the transaction?
Well, I think the answer to that question is yes, based upon where you are. And I agree with you, Andy. If you fail to disclose something, could a seller potentially terminate the contract? I think that answer is yes. I think when you're honest and telling them what's going on and say, whoops, we forgot to make sure everybody's on the same page. So you're trying to do things the right way. That's all well and good. In Texas, we have this thing called the underlying lien disclosure notice that is mandatory for a seller to give a buyer, wherein the buyer can terminate the transaction. It doesn't say the seller terminate, but we like to promote that even though it's a seller obligation to give a buyer, if you are in the investment industry and have knowledge of that, we want to make sure we help our sellers navigate those things correctly because they don't know what they don't know.
Mm-hmm.
And again, here in Texas, we have some things we've got to navigate. We have one called Senate Bill 43, which is the wrap lending bill, in which a subject to transaction is actually defined as a wraparound transaction as well, because it says any transaction wherein an existing mortgage is being left in place. And I was reading this bill just a few days ago, and it doesn't say that you close a transaction. It says whether you contract to close or close, and it binds it together with some different things that are out there as an obligation. Now, one of the good things is there's an exclusionary rule on that regarding a seller's homestead versus maybe buying a non-owner occupied property in some format. But I just think it's important that the marketplace understands their rules and regulations so that can you go back and fix things? You can. And here in Texas, if you don't fix things the right way, it can have some pretty serious consequences.
Yeah. Sean, how would you fix that issue if you fail to utilize the subject to addendum? Maybe you just used the wrong purchase contract, or you're just now learning, well, I got to disclose this. If you don't do it at the signing of the purchase contract in Arizona, is it too late, or prior to close of escrow, can you get that disclosed?
No, in fact, there is no law that you do a subject to addendum. It's just the best practice, like Scott said, which basically the subject to addendum does three main things, right? Number one, it discloses the overall nature of the transaction. It discloses the risks of the transaction. And then depending on how it's drafted, it also provides certain duties and obligations on the seller, such as providing an assignment of insurance proceeds, BOA, those types of things, at closing. And so you could get that signed at any time. Now, if you watched my legal update this morning from our show this morning, there are certain disclosures not in the subject to world, but it could be on subject to transactions that you're looking to wholesale, that if you are a wholesaler in states like Arizona and Wisconsin, you have to make that disclosure at the time that you enter into the contract or at the time that you enter into the assignment. And if you don't make those disclosures, then the other party to the contract has the right to basically walk before closing. And there's no going back and fixing that because the law says you have to make the disclosure at the time the parties enter into the contract. So the only way to fix it would be to cancel the contract and do a new contract with those disclosures, assuming that the parties are agreeable. But if you miss it on that, there's no going back to the seller and say, no, let's do an amendment or an addendum or anything like that. No, it needed to be in there at the time that you did the contract. And so, that does create an issue. But the subject to addendum, you can get that signed later on.
All right. If you're just now joining us, this is the Creative Finance Collective. We are talking about all things creative finance. Couple housekeeping items. There's a barcode at the top of your screen. If you're watching from Facebook, you can scan that. It takes you to your YouTube, our YouTube channel rather, and allows you to subscribe and like. In the description of our YouTube channel video, we also have links to the YouTube channels of some of our guests or participants on the collectives, Scott Horne being one of them. Good place for you to go and find more information about him as well and his channel. Good place all around to learn about creative finance, real estate law, so on and so forth. We're taking questions today for the hour or until we stop getting them. So make sure to keep posting your questions. We enjoy it and like to address them. All right, so we have another question here. Oftentimes we talk about risk to the buyer in a subject to transaction. This question asks about the seller. What is the biggest risk to a seller in a subject to sale? So they want to sell the property subject to what should they be thinking about as the biggest possible risks? What do you think, Scott?
Well, I think number one, first and foremost, is due on sale, obviously, which you want to do your best to avoid and avert. Sellers typically don't have the ability to pay off those mortgages so that it happen, or even know where to go navigate it should it happen. That's where you hope that if an investor bought the home subject to it, they would have that knowledge base that won the ability to cure the issue properly, whatever that might. Understanding by a seller that they have continuing liability on their mortgage until it is paid off, and not to the person buying the home is going to pay the property off in a month or a year or 5 years. It's whenever that loan is paid off, and realize that if you're going to do that, that's a potential risk you have to navigate, for a certain amount of time. I think another risk that sellers can incur out there is, what if the borrower, the person who buys the home subject to, winds up in a bankruptcy perspective? Is that seller prepared to continue making payments on the mortgage to preserve their credit? Or is it possible that property could fall into a foreclosure mechanism? And so those are just a few things I think that I like to at least explain to a seller that are out there. There are other minor things you can come across, such as if this, if the buyer to the subject to transaction isn't making their payments in a reasonable and timely basis, it can have not only a negative, but a continuing negative effect on the seller's credit. So it never gets good. And I think this is where we as investors need to help educate the seller for those exact reasons and ensure they're always protected. So if something was to happen to the buyer, and I don't care if that buyer is a owner occupant or an investor, bad things happen to good people all the time. Make sure that seller has a reasonable exit strategy that's customary and ordinary that allows them to get out and hopefully protect themselves along the way.
Yep. Good information. Sean, did you have anything to add?
So I just want to chime in. I do agree with Scott that deficiency judgments, meaning, hey, look at the property's, depreciated. The lender goes and files a foreclosure because the buyer doesn't pay the mortgage like they've agreed to pay. And the house is worth less than what's owed. The lenders in certain states can get deficiency judgments. In Arizona, we don't have deficiency judgments unless it's a second position cash out refinance. And it's only to the extent of the cash pulled out and not used to make improvements on the property. But in Arizona, any purchase money mortgage given for the purposes of purchasing the property or to build, make improvements upon the property, as long as the residential property, regardless of who's lived in it, et cetera, it doesn't matter, no owner occupant requirement. We don't have deficiency rights. So we're an anti-deficiency state. And so really your main damage in that case would be your credit. But there's other states like in Wisconsin, where I also practice, who do have deficiency rights after a foreclosure. So it really depends on what state you're dealing with as far as that risk goes. But it is a risk if you live in a state that doesn't have anti-deficiency protections like Arizona. There is a major risk. But if you're in Arizona, your biggest risk is really just damage to your credit, honestly. That's really the biggest risk if the buyer forecloses or the due on sale is called. That's your biggest risk. Unless you as the seller have carried a portion of the financing, then you're at risk of losing that if the buyer doesn't pay or if the due on sale clause is called. But other than that, in Arizona, really, it's credit.
All right, a couple more questions from some Facebook users. If I do a novation deal, I haven't heard novations come up in a little while. Should I have a POA created with the seller? What do you think?
Let me jump in there,
All right.
So before you go and you get a POA signed by the seller that actually interjects you in the middle of a transaction, you better review your state broker licensing laws and find out what those state broker licensing laws state and whether or not those state broker licensing laws accept out individuals acting in the capacity as attorneys in fact or agents under a POA. In Arizona, we have that. And we also have pretty strict language as far as if you're a party to the transaction, you're accepted from the licensing laws. We also have language as far as, for, acting in the middle of a transaction or helping to negotiate a transaction for compensation. But there's other states that are going to have more broad provisions that don't just say for compensation, they're going to say or anything of value. So if you insert yourself in the middle of a transaction with the hope that you're going to be able to, or idea that you're going to be able to novate and gain anything of value to negotiate the transaction, and act on behalf of the seller, and there's, you know, nothing in there that exempts like power of attorneys and things like that, you very well are going to could be in violation of the state's real estate broker licensing laws. So be very, very careful on that. Research the laws of the state that you're going to do that in before you take a power of attorney and put yourself right in the middle of handling a transaction or negotiating a transaction on behalf of a seller with the hope of future compensation through the novation. Scott, what's Texas like on novations?
Well,
if you know?
I love what you just said, Sean, which is before you enter into something, know what it is you can or cannot do. And are you stepping on the toes of the real estate commission issues in the state where you're doing business or not? I don't believe we have that issue here that you can have a power of attorney for the seller. My problem with novations is that everybody wants to try to navigate this through a contract for sale with some type of a document that may or may not be filed of record. And they anticipate that some title agent is going to understand what this is, and they really don't. And they may or may not accept it in some format. And so whenever I hear the word novation, you know, I'm always making a recommendation to the clients to go out and to create some type of a corporate entity, at least, where they can transfer the property and protect everybody appropriately, and then navigate the sale of that property through that LLC or that corporation based upon the terms, conditions they've negotiated with the seller. This way, if you're coming out of pocket money to renovate a home, bring a loan current, whatever it might be, the seller's lien is going to be protected. That private lender's lien is going to be protected. And you can then navigate things more appropriately. But I completely agree, Sean. If you don't know what the rules and regulations are, either talk to that knowledgeable attorney, call your state's real estate commission, ask the simple question, know those answers before you get into it. Because the last thing you want to do is step in the middle of something like that and get hammered when you don't even anticipate it.
Yeah, good info. All right, we have another question from a Facebook user. If I buy property sub-2 and the seller files bankruptcy after, will I be at any risk? So seller files bankruptcy. Does the buyer have anything to worry about?
Well,
So
once
it
again,
depends. Go ahead, Scott.
No, go ahead, Sean.
So it depends. You know, if you've closed in the 90 days prior to the filing of bankruptcy, the trustee could potentially step in and declare an avoidable preference and set the whole thing aside. After that, between 90 days and a year, then they can only set aside preferential transfers, you know, basically non-arm's length, I guess is the better term, non-bona fide transactions. And so if it was to a family member, you may have an issue. If it wasn't for, you know, at least reasonable consideration, you may have an issue. Those types of things within that 1 year period after the year, you should be good. Scott, what are your thoughts?
Well, so one, I agree, you know, if you're if the person filing bankruptcy was trying to hide the claw back that property, absolutely they could claw it back. On the other hand, of course, the issue becomes if the investor who has bought this home is current in making the payments. I always tell the investor, I said, first and foremost, the bankruptcy estate does not own this property. You do. If the lender is current in making payments, the lender's not going to have much to worry about through the bankruptcy. But at the end of the day, the bankruptcy court has a lot of power, from what is my understanding. They can navigate these however they see fit in most cases. But if the transaction was to the benefit of the bankruptcy estate to eliminate potential debt, to eliminate negative cash flow and things of that nature that might be ongoing, so it is a positive to the bankruptcy, the great odds are not a lot is going to happen with that. Now, could they possibly discharge the original borrower from obligation with the lender? Yes. And how is the continued payments to the lender, how does that affect that scenario? And I'll be honest, I don't know that answer because I'm not the bankruptcy lawyer. And so normally I tell the investors, do the right thing, maintain it appropriately, and typically things go reasonably smoothly. But it doesn't mean it always will do that, which is why I suggest if you're going to play this game, reach out, actually find a bankruptcy attorney who understands this business and ask them those simple questions and get it direct from the horse's mouth. Just like they should talk to possibly the state's real estate commission to know what they can and cannot do from a brokerage perspective on an ovation, to talking with a knowledgeable bankruptcy attorney and get their perspective on this so that you have a working knowledge of that as you move forward. It just makes life a lot easier if you're going to play this game.
All right. If you're just now joining us, this is the Creative Finance Collective. We're taking questions throughout the hour. So if you got questions, bring them. We're happy to address them. We have another question from a YouTube listener. Do I have any alternatives if a subto seller refuses to grant any POA? I think what this is asking is the POAs that you obtain as part of the transaction to speak with the lender, because the seller's name is going to still remain on the loan, so on and so forth. But maybe you've got a seller that, for whatever reason, doesn't want to grant a power of attorney. What do you do? Do you just walk away from the deal? Is there an alternative?
I'll make the initial comment here that when I'm going to contract to buy a property subject to, a power of attorney is part of my contract package automatically. And at that point, if they're not willing to sign that and or an authorization form, but I prefer the limited power of attorney, I may walk away because it means that that could be an issue or a problem downstream. I've always also had situations where a seller who has a short-term memory doesn't remember the situation when they sold the property, whatever it might be, and they think that by terminating that power of attorney somehow benefits them, and it really doesn't. Again, I think proper education of the seller, proper disclosure is always a huge benefit there. But those kind of things happen from time to time, unfortunately. But if the seller chooses not to execute a POA, and I don't have a good reason, I probably would walk away from the deal. If the seller should terminate a POA after the transaction has been consummated for whatever reason it might be, it's really hard you can't force them to re-sign one. You can just be nice and try to get it re-signed again if possible. But they have the right to do that should they wish to do so. They just don't understand that sometimes they might be cutting off their own nose to spite their face.
Yeah. All right. We have another question from a Facebook user here. I'm working a potential on-market subto deal, and the seller's realtor, executive broker, asked if we can use my contracts and just pay him a consulting fee. Doesn't seem right since it's technically still on market. Should I use the realtor's contracts? Does the question make sense?
Yeah, I would think that first off, any at least here in Texas, a listing agreement can be terminated at any time. If a realtor brought a buyer to the table, they're entitled to get paid, whether the listing agreement has been terminated or not. What I'm perceiving in the question is that they just don't feel comfortable in collecting a commission, and they're just reclassifying that as a consulting fee of some type. And again, I look at that initially and go, if the seller and the agents have all agreed to treat this as a consultation, not a commission, terminate the listing agreement and move forward and pay the consulting fee.
So that wouldn't fly in Arizona, unless it was paid to the brokerage, I guess. That would be okay. But if a broker wants to be individually compensated as opposed to going through their employing broker here in Arizona, you can't do that. So as long as the consulting fee was paid to the employing broker, it's fine. But if the individual realtor or agent is saying, well, just cut me a check individually directly to me and not through the normal processes of what's required by law, that would be problematic. So in Arizona, all commission fees, consultation fees, anything you want to call it, that's to be paid to a realtor for their services must go to their employing broker, not to them individually.
And as the listener can probably imagine, the answer to this question could be sliced 50 different ways, as there's 50 different states. And, a classic example, regardless of what the specific problem is, you want to consult with a knowledgeable attorney in your state to vet through that. Well, guys, we're about 40 minutes in, and we've addressed all the questions available to us. I think we'll go ahead and call it. For those that are watching, make sure to join us every Tuesday on the NREM podcast. And remember, every Tuesday at 2:00 Arizona time, we do the Creative Finance Collective. You can obviously watch this after the fact, but watching it live gives you the opportunity to ask us questions. As I mentioned before, go into the description on our YouTube channel. That gives you links and information to channels like Scott Horne's channel, and other guests that we have. Go there. It's got good information, and they're good follows. Thanks, Scott, Sean, for being on with us. Always a good discussion.
All right, gentlemen, have a good evening.
Thanks for passing the time in the car, guys.
All right.
All right.
Safe.
Appreciate it. Good seeing y'all.